Okay,
This
Bismillahirrahmanirrahim.
meeting is being recorded.
Hi, Assalamualaikum, madam. We are from Group 7. I want to present about three dispute resolution mechanism. Okay, we are group member Nadira binti Zaidin, Husna Humaira, Putri Syahira Shazlin, Syed Abu Bakar, and me, Muhammad Afal Jamal. Okay, next slide, please. Okay, let's move to my part. Definition. Okay, the legal system provides resolution for many different types of disputes. Dispute resolution can be a way of solving a conflict without having to go to court. As a business owner, you should be familiar with and understand dispute resolution processes in case you need to handle disagreements within your company or with other parties. The manner by which the issue is settled might complicate dispute resolution because the various forms of resolution have a variety of factors to consider. Most notably, cost, access, confidentiality, and timelines. There are four main types of dispute resolution: negotiation, negotiation, mediation, arbitration, and legislation. Many different forms of disagreements can be resolved through the legal system. Some will not be able to achieve an agreement through a collaborative method. Some disagreement are necessitable to the use of the state's cocaine authority in order to be resolved. Perhaps more cruelly, when they are involved into a conflict, many people want a professional advocate, especially if the dispute involves perceived legal rights, legal misconduct, or the threat of the legal action against them. Next slide. Okay. Legislation is the most common type of judicial dispute resolution. Legislation begins when one party files a lawsuit against another. The government facilitates legislation in the United States to federal, state, and local courts. The proceedings are quite formal and guided by law created by the legislature, such as a rule of evidence and procedure. The outcome is decided by an impartial judge and or jury based on the facts of the case and the applicable legislation. The court's decision is binding, not advisory. Nevertheless, both parties have the right to appeal the decision to a higher court. Judicial dispute resolution is often additional in nature, with antagonistic parties or competing interests seeking the best conclusion for their position. Due to the additional nature of litigation, collaborators usually choose to resolve problems. Districtly retired judges or private lawyers are frequently appointed as arbitrators or mediators. Nevertheless, trained and qualified non-legal dispute resolution as specialists are forming a growing body within the field of alternative dispute resolution. Many states in the United States currently have a mediation or other ADR programs answered to the court to aid in the resolution of legislation. Okay, that's all from me. I will pass to my next presenter.
Thank you to presenter. Hi, Assalamualaikum. To our beloved lecturer, Madam Nurul Jannah. Before I started to conclude everything in briefly about what are mechanism in dispute resolution on labor law, my name is Husna Humaira. My metric number is DIL 193035. Alright. Before I started to conclude everything briefly, I want to read on the table first. The parties here we can see the conciliations. The parties are an independent third party that will be appointed to reconcile the parties. Therefore, conciliation usually comprise a formal body is the conciliatory body, and mediations the parties here is a mediator, usually is a person well respected in society. While the arbitrator is used to make a decisions for the disputing parties, which are in two forms, either a compulsory arbitrations or voluntary arbitrations. Next slide. All right. Conciliations for the functions of the third party. The third party here for the conciliations is to reconcile the disagreeing parties and wins them over from anger. While the mediations here, the mediator will have the task of bringing a settlement to the dispute. He will lead the dispute to reconcile and reduce the difference between the parties. While arbitrations here, the arbitrator may help to decide for the parties in accordance with the law. In fact, his decisions can be enforced by the court. But what is the effects, right? Okay, for the conciliations, at the end of the process, the party will either reach a settlement according to the mediator's recommendations or the case will be taken to the court. And mediations, at the end of the process, the parties will either reach a settlement according to the proposals of the mediator case that will be brought to the court. Okay. For the arbitrations, mandatory where the parties sign an arbitration clause in the agreements between them. The parties must use an arbitrator to resolve the issue, and the decisions of the arbitrator is binding between the disputing parties. Next slide. Next slide. Okay, thank you. All right. For conciliations, what is the application here is conciliation could be applicable in the process where the third party tries to resolve dispute between employers and employees. Mediations, the Bar Council Mediation Center is available for the parties who agree to seek the assistance of the Bar Council. These types of disputes suitable for the mediation might be family disputes and business or the trade disputes. Arbitration. The rules the rule on arbitrations are provided under the Arbitration Act 2005. Usually, a company's article of associations include a clause that all disputes between the companies and its members are to be referred to arbitration. In such situation, the members of the companies cannot bring court proceedings against the company. Next, slide atas. Okay. So right now I'm going to conclude everything in briefly, okay? For the conciliations first. The LRA 90/16/7 actually gives government employees the ability to serve as a natural third parties in facilitating conciliations meeting between the conflicting parties. Okay, so conciliations can be requested voluntarily by any of the disputing parties or under sections 18 and under section 20 for claims for reinstatement of the LRA 1967. In the interest of the general public, the Director General of Industrial Relations Malaysia, DIRM, may also intervene in a disagreement and order the disputant to attend a conciliations meeting. This is necessarily conciliations in which the settlement decisions is determined quickly, especially if it involves the concerns that may influence to the general public. Right. Conciliations is the main form of ADR that used in the industrial relation departments, as we know, right? So conciliations has several characteristics to be seen as the difference between these three alternatives. Among them is the purpose of the conciliations is to reduce tensions between parties by improving communications, interpreting issues in disputes, and exploring solutions in order to reach the solutions that both parties will agree. All right. If we can see on the table about the parties in conciliations here, it will state that an independent third parties will be appointed to reconcile the parties. Therefore, conciliations usually comprise a formal body, which is the conciliatory body. Okay, unlike mediations, arbitrations, and conciliations, the disputing conciliations parties rarely engage in face-to-face discussions. This is because once the parties agree to use a conciliator, the parties usually mix with the conciliator separately in an effort to resolve the differences between the parties. In this case, the conciliator not only becomes facilitator of the process like a mediator, but it also takes on further roles as an advisor to the disputing parties. Therefore, the conciliator may make advisory comments on the legal nature of the dispute throughout the proceeding to the parties. So, a conciliator who has no powers to make decisions that bind the parties, however, they often have a contract made by the solicitor or conciliator to make an agreement binding if the parties to the dispute reach their agreements. Okay, for mediations, mediator usually is a person that well respected in society. The parties that involved can also be employers and employees, and they can choose to try mediations before using this arbitration. Okay, the Mediations Act 2012 was enacted to facilitate this mediation. To this mediation process, simply put, the parties are free to agree the appointments of any persons as their mediator. The functions of the third party, which is the mediator, is they will have the task of bringing a settlement to the dispute. He will lead the disputants to reconcile and reduce the differences between the parties tadi. But if mediation is unsuccessful, the parties boleh proceed to go with the respective rights in arbitrations. Normally, each party will initiate legal proceeding without first attempting mediation. In such circumstances, it is common for the judge to suggest that the parties try to mediate first. Okay, and if the parties agree, the judge may mediate the matter himself, or alternatively, it will refer the parties to another judge or registrar to assist in mediation. If mediations cannot bring about an amicable settlement, the case is returned to hearing judge for the disposal. Okay, at the end of the process 32, the parties will either reach a settlement according to the proposal of the mediator case, they will be brought to the court. But before, I would like to explain a little bit about Section 5 of the Mediations Act 2012. It was provide what number of methods for initiating mediation. One of them is that the person might start mediation by issuing a formal invitation to a person with whom he has a disagreement. The subject of the dispute must be briefly stated in the writing invitation tadi. The Act has placed a rather onerous procedural requirements to be followed by the parties to initiate mediations, and they are not productive to object and purpose of the Act. For example, verbal consent for mediation does not appear to be sufficient for the purpose of the Act. But if the person initiating the mediations dia tak terima response from the person with whom he or she has a disagreement within 14 days after delivering the writing invitations or within any other times limit indicated in the invitations, the writing invitation tadi is considered as refused. Okay, and lastly on mediation applications here, the Bar Council Mediation Center is available for parties who agree to seek the assistance of the Bar Council. These types of disputes suitable for mediations might be family dispute and business or trade dispute. Okay, the last ones here, arbitrations. The third dispute alternative mechanism is arbitration, which an issue refers to by one or more arbitrator who renders a binding ruling based on the parties' agreements. Rather than just going to the court, the parties boleh pilih arbitration as a private dispute settlement mechanism diorang. Okay, the parties here we call as arbitrator, which is the arbitrator is used to make a decision for the disputing parties, which are in two forms, either a compulsory arbitration or voluntary arbitration. It is categorized by being briefly divided into like a voluntary. Okay, informal, controlled, adjudicative, and advisorial and flexible. Voluntary means that the parties involved must expressly agree to arbitrations in writing. Okay, or if the person so choose to be within the scopes of the law, then it obligates arbitrations in certain situations and it is usually conducted in private. The difference between mediation and arbitration is that the parties will retain full control over the works and outcomes of the mediations. Whereas in arbitration, the arbitrator functions is to decide the outcomes of the proceeding and the parties are bound by that decision. Not just like that, the arbitrator may help to decide for the parties in accordance with the law. In fact, his decisions can be enforced by the court. As we can see on the tables on arbitrations about the application, we can see that the rules on arbitrations are provided under the Arbitrations Act 2005. Usually accompanies article of associations include a clause that all disputes between the company and its members are to be referred to arbitrations. In such situation, the members of the company cannot bring court proceeding against the company. I think that's all from me. And in closing, ADR consists of a variety of techniques, and there are needs and some advantages for other methods in resolving ADR disputes, as demonstrated by high referral for individual disputes and low resolution rates over the years, leading to large backlog of cases ahead of the industrial court. Thank you, and I will pass to the next presenter.
Hi,
Yeah.
my name is Putri Syarash. My name is Putri Syarash Shazli binti Muhammad Sharukama, DIL 193036. I will continue with the best dispute mechanism in settling such a dispute between employer and employee. The conciliation is the best way in settling such dispute between employer and employee. Conciliation is selected because a third party gives assistance with the goals of assisting the parties in reaching an agreement. The conciliator brings the opposing parties together to discuss their differences and aid them in resolving their issues. The Director General of Industrial Relations Malaysia has authority to require the parties to attend a conciliation meeting to the public interest. Government employees are authorized to participate as a neutral third party in conciliation meetings under Industrial Relations Act 1967. Conciliation can be requested voluntarily by either of the disputing parties under Section 18 for the trade dispute and 20 for the claim for reinstatement of IRA. This is a required conciliation in which the conclusion of the settlement is decided quickly, particularly if it involves a concern that may influence the wider public. Only the parties that and their authorized agents are permitted to attend the conciliation procedures. The parties to the dispute cannot be represented by an advocate, advisors, or consultant. Next slide. The conciliation officer works as a facilitator during the conciliation meeting, persuading and inducing the parties to reach an acceptable solution of their dispute. His duty is primarily to bring the parties together to discuss their disagreements, identify common ground, and diffuse tension. He will also explain the appropriate practice and legal concept to the parties so that they are aware of their rights and responsibilities. The conciliation officer will not take side in the argument, and will remain neutral all the time. The parties, on the other hand, maintain the right to say whether they accept or reject any proposed settlement. If the conciliator is unable to reach an amicable agreement, he will submit a report on the dispute to the minister, who will decide whether the case merits referral to the industrial court. It is important to emphasize that all proceedings before the Director General are handled without prejudice. No evidence of any procedure before the Director under Section 20, subsection 2 shall be supplied other than a written declaration in regard thereto agreed to signed by the parties to the reference according to the Section 54, subsection 2 of the Industrial Relations Act. No set time limits for the Director General or his authorized official to make a judgment between the parties, despite the fact that before 1980, the Director was given 30 days to reach a decision. That's all for me. I will pass to the next presenter.
Okay, Assalamualaikum warahmatullahi wabarakatuh, teman Jannah. My name is Syed Abu Bakar Al-Hadi bin Syed Faisal. My match number is DIL 201075. And today I will be talking about the provisions and the cited cases. So to start things off, the Industrial Relations Act 1967 refers to conciliation as a recognized way of settling disputes. Sections 18 to 19 of this act states that where a trade dispute exists or apprehended, that dispute, if not otherwise resolved, may be reported to the Director General by A, an employer who is party to the dispute, or a trade union of employers representing him in the dispute, or B, a trade union of workmen which is party to the dispute. Subsection 2, the Director General shall consider any dispute reported to him under subsection 1 and take such steps as may be necessary or expedient for promoting an expeditious settlement thereof, provided that the dispute relates to the dismissal of a workman. Section 20 shall apply. Subsection 3 furthermore states that where a trade dispute exists or is apprehended, which in his opinion is not likely to be settled by negotiation between the parties, the Director General may, if he deems it necessary in the public interest, take such steps as may be necessary or expedient for promoting a settlement thereof, whether or not the trade dispute has been reported to him. Furthermore, the steps taken by the Director General under subsection 2 or 3 shall include reference of the dispute for settlement to any appropriate machinery which already exists by virtue of an agreement between or applicable to the parties of the dispute, unless A, the dispute has already been referred to such machinery and there has been a failure to reach a settlement, or B, in his opinion, it is unlikely that the dispute will be promptly settled through such machinery. Where after having taken the steps under section 2 or 3, the Director General is satisfied that there is no likelihood of the trade dispute being settled, he shall notify the Minister accordingly, information, documents, and compulsory conference for conciliation. In section 19, subsection 1, where a trade dispute has been reported to the Director General under subsection 18, or where the Director General has taken steps under section 3 of that section, the party reporting the dispute, and if directed to do so by the Director General, the other party shall furnish to the Director General within such period as may be specified in the direction all the necessary information relating to the matter in dispute, together with, wherever possible and appropriate, an agreed statement setting out the points, if any, of which they have already reached agreement and the points on which there is still disagreement. So according to the 24 Laws of Malaysia Act 177, Section 2, the Director General may, if he deems necessary or expedient, direct any person engaged in or connected directly or indirectly with the trade dispute in respect of which steps have been taken under Section 18 to attend a conference to be presided over by the Director General or such person as he may appoint at such time and place may he specify in the direction. The Minister may conciliate in any trade dispute. in section 19A, notwithstanding the provisions of this part, the minister may at any time, if he considers it necessary or expedient, take such steps as may be necessary to conciliate in any trade dispute. Representation in conciliation proceedings. In 19B, subsection 1, in any conciliation proceedings under this part, an employer who is party to the trade dispute may represent himself or be represented by his duly authorized employee, or where he is a member of a trade union of employers, be represented by an officer or employee of such trade union of employers, or notwithstanding anything to the contrary contained in written law relating to the registration of trade unions by an official of an organization of employers registered in Malaysia. Or B, a trade union or workman which is party to the trade dispute may be represented by an officer or employee of such trade union, or notwithstanding anything to the contrary contained in any written law relating to the registration of trade union by any official of an organization of workmen registered in Malaysia. In subsection 2, save as provided in subsection 1, a party to a trade dispute shall not, in conciliation proceedings under his part, be represented by an advocate, advisor, consultant, or by any other person whatsoever. In relation to matters pertaining to labor, conciliation is regularly used in cases of unfair dismissal. In the case of Katira Velu Ganesan and another versus Kojasa Holdings, the Court of Appeal aptly describes the stage claimant will have to go through before his allegation of unfair dismissal may be adjudicated in the industrial court. The conciliatory level is when all the Director General of Industrial Relations is concerned with is whether the parties are able to settle the differences. All that is required to activate the conciliatory jurisdiction is a complaint under section 20, section 1 of the Act. Consequently, there is no question of there being any wider jurisdiction at this stage. Therefore, we may conclude that conciliation is the best way of resolving a dispute, as it is easier and faster because the conciliator is appointed by the involved parties. That's all from me. I will pass to the next presenter.
Assalamualaikum and hi, Madam Jana and all my friends. I'm Nadira binti Zaidin, DIL 193046. And now I will jump to the conclusion. So, to sum up, alternative dispute resolution, or known as ADR, is an excellent way to obtain justice because ADR is a simple way to address an issue since it is less expensive, faster, has more competence, is more accessible, provides conciliation between parties, has less formality, and is less adversarial. In every disagreement that arises will be resolved with proper measures in ADR because ADR has provided many ways to solve the problems because ADR allows both parties to ask a third party to represent them in court. And both parties should inquire about the individual, who is frequently a lawyer or other specialist. The parties must agree to be bound by the decision. As a result, many ADR firms are providing benefits to their consumer as ADR is used to resolve minor disputes. That's all from us. Thank you and Assalamualaikum.